I'll turn to Mr. Jelsma.
Thank you, Madam Chair, honourable senators, and thanks so much for inviting me to appear before this committee today. The international dimensions of Bill C-45 are of utmost importance, not only for Canada itself, but for many countries around the world that are moving in the direction of legally regulating the cannabis market. The position Canada will take vis-à-vis the UN Drug Control Conventions could well be a crucial moment in the long and troubled history of international drug control. Let me also make clear from the start that I do support the policy change proposed by Bill C-45 and that my institute, the Transnational Institute, or TNI, has been actively involved in similar drug law reform initiatives around cannabis in other countries, providing expert advice and facilitating meetings to discuss the dilemmas countries are facing. The UN drug control system was built with the aim to protect the health and welfare of humankind. And the current crisis around opioid overdose deaths here in Canada and in the US is a stark reminder of the importance to safeguard its key principles and to improve the functioning of that system. In that sense, I agree with the statements made last month before this committee by Mr. Gwozdecki of Global Affairs that Canada's approach is compliant with the overarching goals of these conventions, but also with his acknowledgement that it will result in Canada being in contravention of certain obligations related to cannabis. There's simply no way around that. Denying that reality would be dishonest and disrespectful of international law. For TNI, and fortunately for many countries, including Canada, respect for international law is crucial for a basic degree of global order and governance. And pacta sunt servanda, so Canada runs into a legal problem, just as Uruguay and the US already have. A problem that requires due attention and needs to be resolved at some point in the future. From that perspective, we explored with a group of international treaty lawyers, UN officials, government representatives and civil society experts the best options for dealing with those treaty tensions. The outcomes are laid down in a recent report on balancing treaty stability and change that we presented in March at the UN Commission on Narcotic Drugs in Vienna. I would like to request that the entire report also be made available to the committee, and I've brought some copies, printed copies, for those who want. I've been following your committee's deliberation thus far, and I don't want to repeat things from previous sessions. So allow me to highlight just a few key points from our report that haven't received much attention thus far in this committee. First, the inclusion of cannabis, but also of coca leaf, in the strictest control schedules has been a historical mistake, which has weakened and delegitimized the whole system. And the moment is long overdue to repair those mistakes, refocus priorities, and to make the system more evidence-based and fit for purpose. An important step in that direction is the pre-review process of cannabis currently undertaken by the World Health Organization. The WHO Expert Committee on Drug Dependence is mandated by the treaties to recommend on the scheduling of substances, but never in its history has it reviewed the current classification of cannabis, which was basically copy-pasted from the pre-war treaties into the single convention. In June, the expert committee will meet to discuss the outcomes of the pre-review and surely will proceed to undertake a critical review and then provide recommendations for rescheduling. 2. An increasing number of countries are moving towards legal regulation of the cannabis market. The trend is most visible in the Americas, the US states, Canada, Uruguay, and several Caribbean countries like Jamaica and St. Vincent and the Grenadines. But the trend is also getting closer to a breakthrough in some European countries, like the Netherlands, Switzerland, Spain, Germany, as well as in New Zealand and Australia. The trend is also followed with interest in a few African and Asian countries, like Morocco, South Africa, Thailand, Myanmar, and India. All countries where also TNI is actively involved in those discussions. Reaching a new global consensus to revise or amend the UN drug control conventions does not appear to be a viable political option in the foreseeable future. As the 2016 UN Special Session on Drugs, the UNGES, and the latest C&D session in Vienna have clearly shown, the global consensus on drug policy is fractured beyond repair. 3. The nature of the drug control regime limits the formal avenues for consensus-based treaty evolution and modernization, and forces states like Canada that want to move forward with reforms to adopt temporarily a stance of respectful non-compliance or to take extraordinary measures, such as the choice made by Bolivia to withdraw and re-adhere with a new reservation. Also a process where TNI has been intimately involved in. 4. The option of inter se modification based on Article 41 of the Vienna Convention on the Law of Treaties was specifically designed to find a balance between the stability of treaty regimes and the necessity of change in absence of consensus, and appears to provide a useful safety valve for the state of paralysis of the global drug control regime today. 5. An inter se agreement on cannabis regulation would allow a group of countries to modify certain treaty provisions among themselves alone, while maintaining a clear commitment to the original treaty aim to promote the health and welfare of humankind and to the original treaty obligations vis-à-vis countries that are not party to the inter se agreement. 6. An inter se modification agreement would provide opportunities to experiment and learn from different models of legal regulation, open the possibility of international trade between states with regulated cannabis markets, also enabling, for example, small cannabis farmers in traditional southern producing countries to supply the opening regulated licit spaces in the global market. When the inter se option came up briefly in earlier sessions of this committee, the opinion was expressed that the mechanism was only intended for countries that wanted to agree among themselves on stricter rules than what the treaties require, not to reduce treaty obligations. But as we explain in detail in our report, there is no doubt that inter se modification can also be applied by a group of countries to derogate from certain treaty provisions. The UN International Law Commission discussed the matter in great detail and concluded that in that case, basically, the same rules apply for an inter se agreement as for a reservation, namely that it should not affect the rights of other parties, and that, and I quote, it does not relate to a provision, derogation from which is incompatible with the effective execution of the object and purpose of the treaty as a whole. I'd be happy to go into more legal details in answer to questions, but to finish, let me mention briefly two important points around the question whether an inter se agreement to derogate from cannabis-specific treaty provisions would be permissible under those Article 41 conditions. Firstly, it depends on the nature of the treaty. The prohibition of torture under international law, for example, is an absolute principle from which derogation by means of reservation or inter se modification obviously would not be permissible. Similarly, an inter se agreement derogating from provisions of a nuclear disarmament treaty would be unlawful since it necessarily affects the rights of other parties. And that's an example where stricter rules through inter se modification would be lawful. For example, the establishment of nuclear-free zones among some of the countries. But there is more flexibility for treaties where the impact of a specific change between two or more parties inter se can be confined to those parties and has no immediate effect on the rights of others or on the object and purpose of the treaty as a whole. The morally charged 1961 Single Convention perhaps attempted to elevate the policy of drug prohibition to an absolute principle, but that argument is not sustainable, since there are many psychoactive substances, including alcohol, to which the principle is not applied. That brings me to my second point about the permissibility of an inter se cannabis agreement. A majority of countries, at least for the short-term foreseeable future, will maintain a strict prohibition regime for cannabis. So to what extent are their rights immediately compromised if a group of countries decides otherwise? Of course, the regulating countries would promise in their inter se agreements to fully cooperate to prevent leakage to countries where cannabis prohibition remains in place. In practice, there are quite a few examples that demonstrate the possibility of peaceful coexistence of fundamentally different control regimes for the same substance. The Bolivian derogation from certain treaty obligations regarding the Coca leaf does not appear to have affected the rights of other parties in any serious way. Other psychoactive plants like khat, kratom or ephedra are not controlled under the UN conventions at all and are subjected to widely varying degrees of national controls and prohibition. But also in the case of cannabis, by now there are many years of experience with the legal medical cannabis market, allowed under the treaties, but in practice still strictly prohibited in most parts of the world. The rapid boom of the medical cannabis market has taken place apparently without a major impact on those countries that maintained its prohibition. So why would that be different now with the emergence of a legal non-medical market in various countries, as long as it is strictly regulated, as Bill C-45 plans to do? Plainly, the international drug control system is currently ineffective in preventing the international illegal traffic of cannabis, in spite of the near universal prohibition. A strictly controlled, legal, regulated market is likely to prove more effective in preventing the illicit export of cannabis. Thus, though it may seem counterintuitive to some, a legally regulated market may well benefit other non-parties to the agreement instead of harming them. Of course, there will be opposition and the legality of the mechanism will be questioned by some states, as also happened with the Bolivian Coca reservation. At the time, 18 countries registered objections, including Canada, something I hope this government will correct by withdrawing Canada's formal objection against Bolivia, not only to clear the path for a future similar exemption of cannabis, but also out of respect for indigenous rights. In conclusion, from our consultations with international treaty lawyers, inter se modification appears as a legitimate safety valve and perhaps, under current circumstances, even the most elegant way out for a group of countries to collectively derogate from certain cannabis treaty provisions. Therefore, I hope your committee carefully considers the legitimacy of this option for Canada to resolve the approaching conflict with its international obligations, and that your report recommends to the government to explore this possibility together with the growing number of like-minded countries struggling with the same dilemma. Thanks for your attention.
Thank you.